So good afternoon. My name is Dave Michels, and I'm here to talk to you today about the question of property rights in digital files. But first, I'll just briefly introduce myself. I'm a researcher and PhD candidate with the Cloud Legal Project at Queen Mary University of London. And our research is funded by Microsoft. I also teach. I teach cloud computing law both at Queen Mary and at the LSE. And I'm here today as a visiting fellow to the University of Hong Kong at the invitation of Professor Kelvin Low, to whom I am truly grateful. Kelvin, thank you for this opportunity to come here and talk about my research. And thank you also for all of your work on digital assets, from which I have learned a great deal. It's really helped me refine my position. So let's talk about that position then. I am here today to present a simple proposal, which is that the English common law should recognize an in rem property right to digital files in order to protect control over digital files from third-party interference by offering a remedy for return or damages. And it should do so in order to promote human flourishing in cyberspace. So in essence, my proposal has three parts: a right, a remedy, and a reason. Now, I should clarify that when I say digital files, I'm talking about all of the Word documents and Excel files and digital photographs that we create in our daily lives. Essentially, they are digital collections of information that are presented to us as users of computer systems as individual files with distinct file names and locations. So what am I going to cover in my presentation today? Well, I'll start with this proposal for a property right and an associated remedy. And then I want to touch a little bit upon the concept of rivalrousness and how it might apply to digital files. And finally, I'll talk a little bit more about the reason for my proposal, right? The normative basis upon which we should extend protection to digital files. It'll take about 25 minutes. Okay, so what do I mean when I say we should have an in rem property right and a remedy to digital files? Well, what I'm really talking about is a control-based possessory title that protects your control over your digital files from third-party interference. In essence, I propose that our digital files enjoy the same type of protection as the physical objects that we possess. And in my proposal, this notion of digital control plays the role that physical possession plays under the law for physical objects. So at heart, this is an argument of functional equivalence. It is the argument that we can take the rules that have traditionally governed our interactions in the physical environment and apply them to the online environment, right? Or as Schellekens put it, it's the idea that what holds offline should also hold online, right? We can use these same established principles, in this case of property law, to govern our online interactions. Because doing so allows us to resolve conflicts in a way that balances competing interests, just as it does for our physical objects. So at heart, this is really an argument based on the general maxim of justice that like cases should be treated alike. And that, I think, highlights the key question for this debate. Are these like cases, right? Are our digital files like our physical objects in relevant ways, such that we can apply the same rules? Or are they in fact different? I will argue that they are. Kelvin's opinion may well differ. So let's start then by reminding ourselves of how the law treats our physical objects, which are called things in possession. Does anybody know what this is? Crown, very good. That is exactly right. More specifically, it is the Queen Mother's crown, right? It is part of the British royal family's collection of crown jewels. And as such, it is the property of His Majesty King Charles II. Now, this crown is extra special because it contains one of the world's largest and most famous diamonds, the Koh-i-Noor, which weighs in at just over 20 grams and is valued at hundreds of millions of pounds. So it's clearly a physical object of great value. And as such, it can be subject to possession, right? In practice, King Charles can possess the crown in one of two ways. He can exercise direct control over the crown by holding it in his hands, or he can exercise indirect control over the crown. For example, he can store it at the Tower of London in a locked room and make sure that only he has access to the key. In that way, he has indirect control over the crown because he controls the means of access. So under English law, that fact of possession gives rise to a possessory title. And the person with the possessory title is entitled to peaceful enjoyment of the thing which they possess. At the same time, the law imposes upon all others a duty not to interfere with that possession. That duty applies to everyone, which is also referred to by the Latin phrase erga omnes. Now, anybody who breaches that duty, who interferes with a person's possession, commits a wrong. And one of the wrongs is the tort of conversion. Now, conversion is when you deliberately interfere with someone else's possession completely. The classic examples of conversion are taking somebody else's thing or destroying it. Now, in case of conversion, specifically in case of taking, the original possessor has a right to a self-help remedy in the form of recaption. That is, I can take my thing back if you've taken it from me without committing a wrong. So that's one option, to seek the return of your thing. Alternatively, you can take legal action, right? You can call upon a remedy before the courts and ask them to order whoever's taken your thing to return it to you or to pay damages. So let's look at a practical example of how that might work out in practice. So we have King Charles and we have the Queen Mother's crown, right? And King Charles keeps the crown at the Tower of London under lock and key. But Bob has his eye on that diamond. He wants the Koh-i-Noor. Now, let's assume that Bob manages somehow to take the key from King Charles, right? He sneaks into the Tower of London and he takes the crown. What the law does is it gives King Charles a remedy to sue Bob and demand a court order that the crown be returned to him or that Bob pay him damages. So far, so straightforward, right? Things in possession under property law. Now, I would argue that we can apply these same concepts to our digital files. And that is largely because of the security measures that are part of modern computer systems. For example, think about the files you have stored on your local device, like the laptop you might have brought with you today. If you want to access those files, you have to log in through your Windows or Mac OS account. Similarly, when it comes to the files that you've stored in the cloud, you'll need to log in through your Microsoft or Google Cloud Service account. In both of those cases, you'll need to identify yourself to the system through some form of multi-factor authentication. right? You'll need to provide a password that only you know, or you'll use your biometrics, like a fingerprint or a face scan, or you might use a one-time code that is sent to your device or to your email. In addition, you might apply encryption to your files in order to prevent others from accessing their contents. Or you might put in place a password for a specific file, right? So that anybody who wants to open that file needs to additionally fill in that password. All of these security measures allow us to exercise control over our digital files. And specifically, we can use that control to exclude all others, right? I can access the files I've stored on my laptop. You cannot. Unless I decide to share access with you, right? I can use access privileges to share documents with others. For example, that's how we co-author documents in Microsoft Teams, right? We can work together on a document, and I can say, give Grace access privileges and allow her account to see my document and maybe even to edit it. Similarly, that's how I would share photographs with my family in Apple iCloud. So I would argue that this digital control over our files is similar to the way in which we exercise physical possession over the tangible objects that we own. In particular, it's like storing things in a locked room. The password to your computer is like the key to your apartment. And in the same way that the digital control is similar to physical control, they're also both subject to the same kinds of third-party interference. More specifically, somebody can take control over your digital files or destroy them. Let's look at a practical example. Say Alice has stored a file in the cloud, and she's protected her cloud service account with a password, which in her case is password 1234, which is not a good password. Enter Bob. Right? Bob has his eyes on Alice's digital file. And he manages either to guess the password or somehow, in some way, finds out what her password is. He can now access Alice's file. And if he changes the password, then he effectively prevents her from accessing the digital file. Right? He now controls it. And in a worst case scenario, he might delete that file from the cloud server. I would argue that this interference is similar to what we discussed with King Charles's crown, such that Alice should also have access to a legal remedy under property law. Right? Whenever Bob takes control of Alice's file, she should enjoy the same legal protections that she has for her physical objects. That is, she should have a right of recaption to take the file back from Bob without committing a wrong, and she should be able to call upon remedies for the tort of conversion, for the return of her file, or for damages. That's the simple bit of my proposal. Here's where it gets complicated. There is a clear difference here between physical objects and digital files, which is important to recognize. Right? Digital files can be copied in a way that we can't really do for physical objects. This means that Alice and Bob could easily enjoy equal access to the file, right? They could each have a copy of the file. And so this calls into question, for some authors, the rivalrousness of digital files. For example, the Law Commission of England and Wales argues that digital files are non-rivals, and so they cannot attract a property right. In other words, this is an argument which says that these are not like cases. Digital files are too different from physical objects to attract property rights because of their non-rivalrousness. So that takes me to the second part of my presentation. Rivalrousness. So the Law Commission of England and Wales explains that a thing is rivalrous if the use of the thing by one person or a specific group of persons necessarily prejudices the use of that thing by other persons. And this is pretty easy to apply to the possession of physical things, right? We think about a ring, as Bridge points out, a diamond ring cannot support two wearers at the same time. Or as Smith and Newman put it, either I am using the hammer or you are. I approach the concept of rivalrousness slightly different from the Law Commission. And to illustrate that, I'd like to think of our practical example again. It's certainly possible to use a crown in a rivalrous way. For example, only one person can wear a crown at any given time. Right? This is a picture of Queen Mary, after who my university is named, at King Edward's coronation in 1911. Here she is wearing a crown with the Koh-i-Noor in it. Clearly, only one person can wear a crown at any given time. But that's not the only way we can use a crown. You can also display a crown in a museum. In fact, that is what the royal family does with the Queen Mother's crown. It is on display in the Tower of London. And any number of people can look at a crown at any given time, right? In fact, hundreds of tourists do on a daily basis. They go into the Tower of London and they look at this beautiful crown. So I would argue that things are not rivalrous or non-rivalrous. Instead, we can put things to rivalrous or non-rivalrous uses. And that control over how we use our things, that is rivalrous, right? You cannot wear a crown and display it in a museum at the same time. Those things are mutually exclusive. And so it is the possessor who has the right to decide on the use of their things. And that possession of tangible objects is what is rivalrous. And I would apply the same argument to digital files, right? You can use digital files in non-rivalrous ways. You can share copies of your digital file with everyone in this room, and then we can all enjoy access at the same time. But you can also use digital files in rivalrous ways. I think editing files is the clearest example of that. We think about writing a Word document, preparing a set of PowerPoint slides, or editing an image in Photoshop. Only one person can do that at any given time for that to be a meaningful exercise, right? We cannot all write the same Word document at the same time. In other words, a Word document does not permit two rival authors at the same time. We can work together on a Word document. We can have a group of editors working together at the same time, but we cannot have rival groups editing the same digital file at the same time, because doing so would result in conflicting edits that would render the file useless. Put it in the Law Commission's language, I would argue that the editing of a digital file by one person or a group of persons necessarily prejudices the editing of that file by others. Or simply put, either I am populating this Excel sheet or you are. And so I would argue that just as our physical things, files are not rivalrous or non-rivalrous. They can be put to rivalrous or non-rivalrous use. And that decision over how we use our files, that is rivalrous, right? We can decide to share them widely and give everyone copies, or we can decide to impose access restrictions. But we cannot do both at the same time, right? A file cannot be both password protected and not protected, or both encrypted and not encrypted at the same time. And so, as it is with possession, so it is with digital control. Control over digital files is rivalrous. So it's true to say that Alice and Bob could share access to the same digital file at the same time. But whether they do should be Alice's decision. So to sum up my proposal then, I would say that digital files are like physical things because they can be subject to digital control over use in rivalrous ways. And it's also possible for third parties to interfere with that control. And the law should respond by offering a remedy for return or damages. So that's a lot about rivalrousness. For the final part of my presentation, I'd like to turn to the reason for this protection, right? Why should we do this? And I argue that the law should offer the same kind of protection for the same reason, which is to create the conditions for human flourishing. That's a rather grand claim. So let's see what I mean by that in practice. Again, I think it's helpful to look to the existing law and look at the normative basis for protecting possession to physical things, right? We can think of the right to property as a right to liberty. As Penner puts it, property gives each of us a protected sphere of indefinite and undefined activity within which we can do with the things that we possess whatever we choose within the limits of the law. And this protects the exercise of our natural powers, our intellectual and physical capabilities. In other words, property gives us a freedom to act through the objects that we possess, to use them in ways of our choosing, free from outside interference. As Classe puts it, private property provides the material basis for exercising individual agency. And that gives each person a level of control over their own life. It allows each of us to function as a free and autonomous agent. By that, I mean we are free to set our own goals, to choose our own means, and to act upon those choices, including by acting through the things that we possess, without having third parties interfere with our enjoyment of our things. This builds on earlier work by Martha Nussbaum, which argues that property rights give individuals a level of control over their environment. And that, in turn, allows them to express their capabilities. It allows them to engage in practical reason, to use their imagination, and to engage in all sorts of acts of self-expression. That lets us live what she calls a fully human life. It provides the conditions for human flourish. Now, of course, this does assume that you have some level of possession that is worth protecting, right? You need to have some objects to act through in order to self-express. But this argument is not about the distribution of assets throughout a society, right? That is a separate question of public policy. The point here is simply that each of us has an equal right to the peaceful enjoyment of our things, right? Whether you have a crown or a baseball cap, you have the right to use that thing in ways of your choosing, free from third-party interference. And so I would argue that that same normative basis for protection applies to our digital files, right? Digital files are tools for self-expression. We can use them to store and edit and share information with others. This allows us to exercise our reason, use our imagination, and build relationships, to engage in academic, artistic, and commercial pursuits of our choosing. That value is worth protecting online just as it is offline. We should all be entitled to the peaceful enjoyment of our things, whether those things are diamonds or digital files. That allows us to express our capabilities and provides the conditions for human flourishing in cyberspace. So that's what I wanted to say for today's presentation. I hope that's helped clarify my proposal for an in-rem property right to digital files that protects your digital files from third-party interference through a remedy for return or damages, and does so in order to promote human flourishing in cyberspace. I hope that this proposal can help you think about ways in which we can extend property rights to digital files. So all that remains for me is to thank you for listening. Thank you again, Kelvin, for inviting me. This is research in progress for us. We hope to have a draft paper ready for SSRN by the end of the year. If you're interested in our research, please do add me on LinkedIn. Thanks again for your time. I look forward to hearing what Kelvin has to say, and I look forward to answering your questions.